Hi everyone, so this is another problem question that I'm going to run through, and it's split into two parts. So in this part we're dealing with two of the scenarios, and in the next podcast we're dealing with the second part. So the basic scenario is this: Ines makes the following bequests in her draft will, which the partner in the law firm you work for wants you to review, indicating whether the bequests would be valid and whether any changes are needed, and do that under trust law only. So this is just to avoid confusion. Because it's a will, are we looking at succession? No, we're not. This is an online module on trust law. So in this podcast we look at scenarios A and B, and then the next one C and D. Now it's quite important to have a clear idea on the kind of sort of, if you like, Ponzi terminology, pretentious terminology, but it's kind of used, it's used in the cases, it's used in the textbooks, so we might as well get used to it. So bequests just means that, this is what the will provides, okay? So bequest is something that you leave in your will. So here we have Ines, who is, because this is a will, she's not a settler. Well, she is a settler, but we call a settler in a will a testator. Okay, so just to get rid of the confusion about terminology. So she's making this draft will. You work for a law firm. Your partner said to you, look, have a look at this. Tell us if what she's written would be valid under the law, and if it isn't, what changes would be needed. Now, whenever we talk about validity of any kind of trust, we're thinking of three things. First thing we're thinking about is the three certainties. So does what they've written, in this case it's in writing, what they've written, does that meet the requirements of night and night, certainty of intention, objects and subject matter? Secondly, does it meet the formalities? Now, because this is in writing, it's, you should make an initial point that because the will is going to be in writing, or you assume it will be in writing, it should be in writing. Of course, it's a will. You can't just there's a whole set of different rules that we'll come across later on about imperfect gifts and so on, and leaving a will verbally and then dying before you can put it down, or getting ill before you can write it down. That's a separate issue. But everything here will be done because it's a will in writing. Now, that's good because, as we know, formalities for land require any kind of trust for land to be done in writing. If this is an express trust, right? Resulting trusts and constructive trusts are a completely different regime, which we tackle separately. So it's worth making the point at the beginning that because it's in writing, and presumably will and should be a deed if there's any land involved, then that should be enough to address any kind of formality issues. Another big point to make is that when it comes to each bequest, you need to think about how that property will be vested in the trustee. So in other words, not only must the will say, I want to create a trust in favour of Jim with Helen as trustee, the will has to at some point provide for the transfer of that property to the trustee. And we call that, again, pretentious term, but we should get used to it, vesting the property or constituting the trust. So you constitute the trust by actually transferring the legal ownership to someone. And obviously that can only be done at the point at which, in a will, the person passes and the will becomes effective. Okay, but these are kind of two kind of main opening points that you can start off with in pretty much any kind of problem question that talks about validity. You don't need to talk at length about it because, the odds are that because this is in writing, it will be a deed. So that solves the problem of transferring trust property in land, and the odds are that it will provide for some kind of conveyance within the will, or will cross-refer to a document that does that. So let's look at the particular provisions that, or bequests in A and B. So scenario A says 17, so this is Ina saying all this in her draft will, 17 of my 20 bottles of wine, all in the cellar, all Castle Bourget 2005, to be held by Sunny Gavaskar for him and his family's investment or use. So we should always split up 3 certainties, address all of them, even if to say this is very clear, there's no problem here. I've put a couple of asterisks next to what I think is the kind of nub of the problem of the bequest here, which is certainty of subject matter. That's really the issue. And to a lesser extent, there's a little issue under objects. So just to remind you, the hallmark of a trust is 2 things. So if we want to establish certainty of intention, we have to show 2 things. That there's been, or that we intend to split the ownership between 2 different sets of people. So there can be a bit of overlap, as there is here, because Sunny is both a trustee and part of the beneficiaries. But as long as it's a different group, then there is a splitting of ownership, and we have to show that the settler is imposing a kind of a legal duty for the trustee to act in this way. So here there seems to be no problem, because we can take it from the word held that Sunny is the trustee and that he is doing so for himself and his family as beneficiaries. There's nothing to suggest that there isn't a legal obligation to act as trustee. So certainty of intention is almost certainly there. More difficult issue is the fact that she leaves only 17 out of the 25 bottles of wine, and that should conjure up ideas around Re London Wine and Re Gold Corp. Re Gold Corp, of course, is persuasive authority, whereas Re London Wine is binding authority. Gold Corp is Privy Council. Re London Wine, they said, when we're dealing with fungibles, even if they're the same, they need physical separation in order to constitute a trust. Now, they're not physically separated because they are part of, I should say 17 out of 20. 17 out of 20 bottles, so only 3 are not going to be taken on. However, the law is very clear and formalistic in this respect, and requires physical separation of that which you're going to create a trust property over. Now, you could make a fairly decent argument that should we really be following Re London Wine in the context of a will? Because in both Gold Corp and Re London Wine and other cases that deal with physical separation, like McJordan Construction, which dealt with cash, the common denominator between all those cases was the insolvency of the person holding, or the company holding, the fungible product. So the wine in Re London Wine, the gold in Re Gold Corp, the cash in McJordan Construction. So you could separate them, you could distinguish them on that basis. The problem with that argument is you're essentially saying that a trust can exist on a different basis depending on the scenario it faces, and that's kind of a very dangerous argument. So you're saying if there's an insolvency situation, yeah, you need physical separation and that will create a trust, whereas in a non-insolvency situation that won't be necessary. So a couple of problems with that. Firstly, how do you know then that a trust has been created? Do you have to wait until insolvency has happened to figure out whether a trust exists? Secondly, there's something very artificial about saying that a trust can be created in two different ways, depending on the scenario. That seems arbitrary. On the other hand, the Re London Wine case and Re Goldcorp case are extremely harsh cases, and you can see them as policy decisions. I think on balance the better argument is probably that Re London Wine is binding on us, and the solution actually is very straightforward because we're dealing with a draft will that hasn't yet been put into practice, which is the settler should just separate them out and put them in separate rooms and put a label on them saying trust property, and therefore the issue goes away. Or put them in a cupboard, so put them in one place with no other bottles of wine. So that's easily solvable. So the rule sounds harsh, the rule sounds complex. The arguments around it sound complex, but the solution is actually really, really straightforward. And that's probably why there's a harsh rule, because the solution is really easy. And then we come to Sonny's family. So are we talking about his immediate family? So, if he's got a wife and kids, them. Are we talking about his extended family, like his mum, his sisters, his brothers, if he's got any, his aunts, his uncles, like who exactly? Again, solution with that, very straightforward. You can say, his wife, Mervat, his daughters, Jenny and Jane, and his mum, Yvonne. Although I'm not sure Sonny would have a mother called Yvonne necessarily, but you never know. There you go. So that's quite straightforward. The issue on certainty of intention, not really an issue at all. Very, very clear. Certainty of subject matter requires a bit of discussion around Re London Wine and that kind of case law. But again, solution, even though you could argue that, the common denominator between all the cases saying that they require physical separation for certainty of subject matter, actually, this isn't an insolvency situation. But as I said, I think it's very risky argument to try and run. I think you should mention it if you want, but I don't think you should come down and say, we should ignore Re London Wine and we should just do something different, when all the authorities are kind of consistent with Re London Wine. So I'm thinking of cases, as I said, like McJordan Construction, the Privy Council decision, which is very persuasive in Re Goldcorp and was relied on in a whole load of other cases. So I think it's pretty clear separation's needed. And then on the objects requirement, again, there's no major issue here, but there is an element of conceptual uncertainty, because this is essentially a discretionary trust. Can we really name everyone who falls within the family? How far do we go with that? So again, very easy to set out who those are, and it says name them with a caveat, and it could be that the caveat would be any future children of Sonny and his wife Jane. So you can provide for future changes. So you can define it in whichever way Ines, the settler testator, actually wants. So that's scenario A. Scenario B, this is again Ines's bequest, 3,000 in cash, and found in my desk drawer at home, hoping that this will help Peter Gatting help his kids for once get on with their education. So I think the issue here is mainly certainty of intention and the issue of precatory words. So again, remember, certainty of in a problem question, you don't need to keep defining the certainty of intention. If you've done that once, I'm just doing it here because it will help you follow and get to grips with the law. So have we split up ownership? Seemingly, yes, because Peter is going to get the money and it's there for the benefit of his kids. So there is a splitting of ownership. The issue of precatory words comes in where we're trying to figure out if there's actually a legal obligation on him to use that money to look after the kids. So the word hoping suggests that there isn't, because if you give someone something and say, I hope you use it to do X, Y, and Z, you're not putting a legal obligation on them to do it in X, Y, and Z. However, this isn't a straightforward precatory word thing, because Inas also uses the words for once, which connotes that Inas is unhappy that he doesn't look after his kids and therefore is imposing a legal obligation on him to do that. Now, I would say as a result of that, on balance, and you can use words like that in exam situations, if there's no clarity, you don't have to create clarity. So you could say it's unclear how the court would go, and on balance it probably would say that the use of the word for once is counterbalances the word hoping. But that, again, it would be very straightforward for us to make this clearer. In other words, to get rid of the word hoping and for once, and to just say 3,000 in cash to Peter Gatting, and so that he uses that money to help with his children's education. And she may want to specify how exactly he could use it. So for tuition, for private tuition, for example, or whatever Inas has in mind. So, but the key point is to get rid of hoping, and there's no need then for the phrase for once. That's certainty of intention. So splitting of ownership seems to be there. Uncertainty because of the use of the word hoping and for once, which both push in opposite directions. Hoping seems to suggest there's no legal obligation. For once, that he should help his kids for once, suggests there is a legal obligation. On balance, a court would probably think of this as a legal obligation, especially if it wasn't drafted by a lawyer. Now, problem is, of course, we are lawyers, we are looking at it, and therefore those words need to come out, and then everything should be hunky-dory. Certainty of subject matter. So this is potentially the same issue as Re London Wine. Again, we're assuming there's only £3,000 in cash, in which case there's no mixture, there's no problem. Assuming that I read £3,000 in cash to be found in my desk drawer at home, right? Assuming there's no other money. Now, Re London Wine was the authority for fungibles, in other words, for stuff that can decay and has a time limit. But this isn't really the authority for intangibles. The authority for that is Hunter and Moss, which dealt with shares. And you remember that the shares were 50 out of a larger bulk. But that larger bulk were all the same type of shares, so they all had the same rights attaching to them. So it actually made no difference which ones you gave. So here, even if, we don't know, even if the £3,000 is part of a wider amount of cash stashed somewhat unrealistically in the drawer, but a bit like jokes, problem questions have to deal with unrealistic scenarios just to get you to talk about legal issues. Solution is easy here. We just clarify that We don't need to, but we just put the money in a bank, in a separate account, and call it a wills account or a Peter Gatting trustee account. Unless she's going to give it to him, she's got no reason to touch it, so she can have a separate account for it. And again, when things happen, Pete will get the money. In terms of objects, Peter's kids have a conceptual uncertainty, in the sense, are we talking about his current kids, any future kids, any kids with a different partner? Who are we talking about here? So again, solution very simple, that we actually just define who they are and say, if we want to caveat that and say, any of Peter's future kids, Inas may want that or may not want that, we'd need to get her instructions. So again, you can say that. So looking at that again, the main issue is certainty of intention here, not in terms of splitting of ownership, because that looks as if it's happening. However, to have certainty of intention, not only must you show an intention to split ownership between a trustee and a beneficiary, but you also have to show an intention to impose a legal obligation on the trustee to act in favour of the beneficiaries. Otherwise, this is just a gift. Okay, so those are the two options. Now, it looks like, because you're using the word hoping he uses that money to look after his kids' education, you're not imposing a legal obligation on him. You're just giving him a gift and saying, look, I hope you use it wisely. But then Ines also says, but to use that money for once to help the kids. And it implies that the kids don't, either Mike or Peter or the kids don't really care about their education. So with a gift, you could do what you want with it. But with a trust, you can't do what you want with the asset. So I'd say, on balance, it's probably a trust. But because we're lawyers and we want to make this foolproof, we're going to have to get rid of those words. Certainty of subject matter, again, try and be creative in the sense of, covering all bases. If it's just £3,000 in cash in a drawer, no problem. Even if it's £3,000 in cash as part of, let's say, £5,000, we can use Hunter and Moss to say, look, doesn't matter because, each pound is worth the same thing. It doesn't matter which 3,000 you give. Simplest thing is, instead of, leaving something in a drawer, you put it in a bank account with Peter's name on it, making him the legal owner in due course. Peter's kids need definition, just to be absolutely sure who we're talking about. Are we talking about the existing ones, Fred, Jane and Harry, or are we talking about any kids that he may have in the future? So that's that. Scenario A and scenario B dealt with. The next podcast deals with the two further scenarios, and that's in the one that follows. I hope this is useful. If you do find this of use, please do like it so that people get to see it, get the fruits of my wisdom and insights.